Trying to get some light. Hey, that's a little better. Rita, do you want me to kick off right at noon? I mean, yeah, noon.
Yeah, I see people are logging in right now. So thank you for your patience. We are going to start just a couple minutes right after noon. We're going to give everybody a chance to log in. I think we've got, like Paula mentioned, a room full of folks over at NARPM participating. And then we've got, I think, about 30 or 40 people being scheduled to participate today independently. So we're about halfway there. So we'll just give everybody a chance to log in, and maybe just a couple minutes after noon, and then I'll let you take over.
Thank you.
Thank you. Paula, who did you say your group would be under as far as name?
Connie Wilkins.
Okay, let's double check and see if they are there. Yep, I see them there. So, or her there, so they should all be ready. Okay, we'll give one more minute and then we'll let everybody go. All right, Paula, I think we are good. A couple minutes after, so I'm gonna go ahead and give you the floor.
Thank you so much, Rita. Welcome, everybody. Thank you so much for joining us today and for our webinar on courts after COVID. This program is being hosted by HAR in partnership with NARPM, National Association of Residential Property Management, and we're the Houston chapter. And we're all meeting today on the side as well as this webinar, and we're super excited about it. So I'm Paula Cleveland. I'm the Houston president this year, and I'm also your chair for HAR Property Management Subcommittee. Today, you're going to hear from our expert, Kyle White. He will give you an update regarding the ongoing changes of state and federal orders relating to landlord-tenant lawsuits, including but not limited to CDC orders, Texas Supreme Court orders, and the DTPA changes. He will discuss specific justice of the peace court rules and various approaches to the state and federal orders in place and what that means for property managers, landlords, and tenants in Texas. I want to let you know that today's session is being recorded and it's going to be distributed to everyone who registered for today's class. If you did not individually register, you'll be able to access this webinar online at www.har.com/HARTV. And finally, before I pass the virtual microphone off to our expert, I would like to remind you to put your questions into the chat throughout the afternoon. And you can choose for the questions to go to everyone or just panelists, but all questions will be fielded and addressed as time permits. So let's get started. Kyle White is our local real estate attorney who primarily handles landlord-tenant cases. He has handled eviction cases in 34 different counties in the state of Texas for various apartment complexes, property management companies, and private residential rental landlords. In addition to handling evictions, Mr. White has argued almost every aspect of landlord-tenant law from the justice court level to the appeal courts in various counties. Thank you again for joining us. And now I'm going to pass it off to Kyle. Hey, Kyle.
Thank you, Paula, and thank you for the intro. Let me see if I can get my screen shared here. Okay, can you see my screen right now? Got it. Okay, sorry about
We
that.
can see it,
Okay.
but your camera went off, so we can't see you anymore.
Okay. Give me just a second. Okay, everything
we
should
go.
be up now. All right. Yeah, so like Paula said, my name's Kyle White. I've given some of these talks before. Today it's going to be pretty specific. I know some people had written in and requested different things that I've covered in different topics before. However, we're going to really stick to just kind of the courts after COVID and DTPA because those are really the biggest changes right now, especially for property managers to look out for. The first thing we're going to address, though, here's my contact info. I think most of you probably already have it. There it is, though, if you need it. Again, though, just put the questions in the chat or stop me if you're live on here if you want to do it that way. For those of you sitting in the room, we can do it that way too. First, we're going to talk about the CDC order. Just a second, let me get this moved off my screen. Sorry, I'm just trying to get the chat pulled up here too so I can see what. Okay, so again, we're starting with the CDC order. It has been extended to June 30th. As of now, that's when it's set to expire. To date, it's been extended 3 different times. Landlord-tenant attorneys really across the entire state of Texas are kind of torn as to whether this is going to get reset or not. As of now, it's June 30th. Foreclosures now, they're trying to push through December 31st. So there's lots of talk that the CDC order could potentially be extended. As of now, it hasn't been though. So June 30th is the date. And basically what this order did is it, directed landlords that they couldn't evict a tenant on a non-payment case if the CDC order / moratorium applied. What we're going to talk about, though, as I'm sure many of you have heard, is whether it's unconstitutional, what's happened with these different orders expiring, does the CDC order still apply or not, and we'll kind of get through that as we go through these slides. The biggest thing I think to keep in mind is that the Texas Supreme Court really has kind of battled with the federal government through this thing where the CDC order is still in effect. Don't let anybody tell you it's not. We'll kind of get to the point, but there are 5 cases to date that have ruled the CDC order unconstitutional. However, all 5 have been appealed, and to date, none of those have become final. So as of now, this order is in effect. There is nothing to say it's not. I keep getting calls of that. Well, this federal court said it's unconstitutional. Yes, they did, but it got appealed. Order's been stayed. Nothing is final. The order is in effect. And what affected this was, in Texas at least, was the expiration of the 34th emergency order. This order is what set forth the requirements that required a landlord or property manager or attorney for either of those, where they had to file specific affidavits or something with their eviction that stated whether the tenant had filed a CDC declaration, if the CARES Act was involved, whether you reviewed the Texas Eviction Diversion program. There were just several things within these affidavits that courts were putting out. The 34th emergency order, though, expired. And that's what ordered the courts to comply and require the landlords to file this affidavit. And again, like I said, each one of them had their own affidavit, or if you were hiring attorneys, they were just kind of using their own. However, that order has expired, which required the courts to require you to do that. So by doing that, that's where a lot of people key in, and they think that that you go into these justice courts and they tell you that, well, the CDC order doesn't apply to this court anymore. And they're right with that. The judges don't have the authority to conduct any proceeding regarding the CDC order due to the Supreme Court order expiring on March 31st. But again, like I said, the federal order is still in place. So you may be complacent with state law, but it doesn't mean you're abiding by the federal law that's still in place. So this order that is still in place, this is kind of the short rundown of who it applies to. So it's landlords, agents, attorneys, and property managers if the tenant gives a CDC declaration. And many have asked, do they have to file it with the court? No, they don't. The requirement is only that they give it to the owner, landlord, or agent for the owner or property manager. So simply just mailing it to you, you received it, you've got it. So moving forward on that, any penalties associated with it, you could be fined for because you have received it, so long as they can show they sent it to you. But it does not have to be filed with the court. Here, the actual declaration that the tenants have to submit. Again, I mean, it's called a bunch of different things, but it's the CDC Declaration. It only applies to non-payment of rent cases. Many people have thought throughout the entire thing they couldn't evict at all, which wasn't the case. If it's a holdover, if you had given, lease terminated, and you were just giving a notice for holding over beyond the termination date, CDC doesn't apply. Lease violations, smoking, animals in the property, illegal activity, it doesn't apply. It only applies to non-payment of rent cases. And then there have been some property managers and landlords that have filed and they said, well, there are lease violations, but they didn't pay too. So I'm going to file for all of that. Well, you've just included non-payment as a reason. So now the moratorium is going to affect your case. So as of now, up until June 30th, if you have another reason to evict, do it for that. Don't do it for non-payment. Again, we're going to get to the slides in a minute that kind of assess all the penalties and different things that associate with this. But again, only applies to non-payment. Another thing they do have, the affidavit they're giving, they have to declare under penalty of perjury that they're affected in some way by COVID. And that at the onset of this was what caused a lot of the fights among the courts as to how you were affected. This is the actual language. I'm sure most of you have seen it. This is what's actually in the affidavit. At the onset of this, when the Texas Supreme Court's order was still in effect, we could contest these CDC affidavits and walk in, and we had a list of questions we were using. But generally, if you could defeat one of these topics, you could move forward in some courts. Some Harris County courts, they weren't allowing you to contest it, period. There are still some judges in Harris County, depending whether you file like in JP 1-1 or 1-2, some of them still aren't allowing evictions. They may let you file the case, but they're just putting evictions on hold. They won't hear the case. So again, it's this language and then this what we have on the next page. Again, you really just had to attack one of them. However, again, with the Supreme Court order expiring, that's what kind of threw a big mess into this, that the JP judges backed off and said, well, we don't have jurisdiction to hear any of this anymore. We can't allow you to contest the CDC affidavit. We really can't even talk about it. But keep in mind, if you move forward, you are violating federal law. So again, this is kind of the language. This is what goes into every affidavit. They have to claim all of these under penalty of perjury. During this period, is the tenant still responsible for rent? If they can show they're a covered person, so they filed this declaration with the court, and they are trying to get protections afforded under the CDC moratorium, they are still responsible for rent. So, we have plenty of landlord clients right now that haven't received rent in 8 to 12 months. They're still liable for that amount. So once this order is over, if you weren't able to get money through some assistance program, you can still go after them for all the back due amount. Just keep in mind, whether you're going to get a judgment that's actually collectible or not. But again, they are still responsible for all the rent that they haven't paid under the order. Sorry, my chat box just Okay, so this is kind of where the JP judges are pulling what it is they can do right now. So prior to the COVID order and the CDC order coming out, evictions were governed by Rule 510 and Section 24. That really contains everything you need to know about eviction lawsuits and what that 34th order and every other one before that, from the 33rd back down to the 1st, it just amended the way in which the courts required you to file different things. But like I was saying, justice courts are now the opinion that since their state law expired, they no longer have to really play by the rules of the CDC moratorium. Again, though, like I said, these are the rules that are applying now. 34th order is expired. CDC order is still in effect. This is probably one of the most important points, I think, of the entire PowerPoint we say today is, should I evict my tenant right now or should I wait? So again, the CDC order is still in effect. The penalties for violating that are extremely excessive and strict. I mean, it's upwards of $100,000 fine, up to a year in federal prison. A lot of people have asked, though, well, have they done anything yet? Has there been a case where someone's actually gotten in trouble for this? And no, it hasn't. The Department of Justice would actually have to come after you to try to prosecute on this. And there's such contentious case matter regarding this that I don't see it happening. But keep in mind, if it's a non-payment of rent case, your tenant files a CDC affidavit and you go forward, you could be responsible for all the penalties associated with this federal order. So again, I mean, and just because you file the eviction, the way courts have been advised through the Texas Justice Court Training Center, which is where all the JPs in Texas are trained, they have been advised that, it's up to the landlord whether to proceed forward or not. A lot of courts we're going into, though, the judges aren't really giving instruction on this. And the few that are really kind of taking it to extreme levels, because some courts are, they're giving you a piece of paper or affidavit before you proceed forward that says the judge no longer has any authority to rule or hear issues related to the CDC order. However, the federal order is still in effect. So by you signing this, you're acknowledging that you're not violating state law, but you are violating federal law by moving forward. So keep that in mind, whether you want to evict or not. Additionally, just because you file the suit, even if you get a CDC declaration received by your tenant, the court can still abate, is what they call it, or reset the case, so that you can stay compliant with the federal order, but your case is at least in line. Because there are several courts in Harris County, specifically Precinct 1, Precinct 4, and Precinct 5, that have a backlog of almost 2,000 eviction cases in those courts. So the people that are saying, no, I'm going to wait till the order expires, keep in mind you're going to get pushed behind all of that. And yes, evictions, they have to set hearings between 10 and 21 days. That's the rule. But we're really not in regular time. So I would fully expect courts to be setting these 60 to 90 days out, as backed up as they are when this order expires. This kind of goes into what I was saying at the beginning. Can you contest the tenant CDC declaration filing? Prior to that order of the Supreme Court expiring, you could do it. The issue now is that the justice courts claim they don't have the authority to hear it. So you get one filed on your case and then they ask you, do you want to go forward or not? Well, no, I don't want to go forward and violate a federal law. Can I contest it so that at least you'll sign an order saying that the CDC order wasn't valid and neither me nor my owner or client can get in trouble for that? But the JPs aren't allowing it. So here you have a CDC declaration and your choice is really going to be move forward with the eviction and subject yourself to possible fines, or ask the court to reset the case and hold off until the order expires. So again, here, this is just kind of, ensure you've talked with your client, I guess, on a lot of these, if you're a property manager, to determine whether you want to move forward or not. Initially, the ruling was that only the owner could be responsible for those fees. But the Consumer Financial Protection Bureau has come out and said that not only can attorneys and agents, such as the different eviction service companies, but also property managers are also liable for these fees for acting as an agent moving forward on the eviction. So keep that in mind, that you, your client, everyone involved could be liable for these fees if the Department of Justice were to start going after people, which to date they haven't gone after anyone in Texas, but it's not to say they won't.
Kyle, we have a question. Would you like to field that now, or would you like for me to hold it?
Yeah, go ahead. Is it in the chat or somebody's asking live?
Yeah, it's in the chat.
Okay. So the question asked is, if a tenant abandons the unit and provided the moratorium, would it be a violation to move them out? Well, again, I mean, the abandonment, it's all going to come down to your lease agreement as to how abandonment is defined. But there are plenty of property managers going this route. The best case is to get something in writing showing that they've abandoned the property. I know a lot of times they don't do it. So, what I would suggest is doing some type of abandonment notice on the front door seeing if you get any response. Generally on these, what we like to do is 10 days. Just, I know a lot of people will say, well, my lease says 1 or 3 or 5 days. Well, 9 out of the 14 justices in Harris County want to see at least a 10-day notice. So you may go with a shorter amount and you may be successful with it. But from our experience, I would say to do a 10-day abandonment notice and proceed forward that way. Because if they've abandoned the home, you're not evicting them anymore. So at that point, no, the moratorium doesn't really apply because you're not proceeding forward with the eviction. You're just getting the home back from abandonment. These are 3 or 4 of the current pending cases. It's up to you whether you want to read them or not. Like I said, there are 5 to date that have held the CDC order unconstitutional. Again, though, it was held unconstitutional in the district court, and every single one of those was appealed. And the United States Appeals Court, can take 1 year up to 5 years that they actually contain jurisdiction on these things. So, when you have an order that's set to expire to June, or even if it gets pushed to December of this year, your hearing in the appeals court's probably not happening until next year. So again, none of these have become final. So as of now, the CDC order is still in effect. And again, these are just some of the cases that have tried to take it on. So this is, how are the courts currently handling it if a CDC affidavit's on file and it had been reset, several times due to it? Well, most of the courts we're working with are setting status hearings, and asking the landlord, do you want to move forward or not? And then some, precinct 1 in Harris County that, has the office on Shepherd, and then the one right in downtown Houston, they are requiring landlords to complete affidavits saying, I understand the federal penalties, but I still want to move forward and evict the tenant. And again, it's your choice, but keep in mind, everybody involved in that, property manager, agents, eviction companies, or attorneys, plus the owner, could be liable for those fines and the prison time associated with it. So the most recent case, this is the one that caused all kinds of news. It was all over, the news everywhere, and people were calling in about it. It was the Federal District Court in Washington, D.C., that on May 5th, they issued an order saying that the CDC order was not constitutional and it violated the Public Health Services Act. That specific court said, yes, CDC order should be set aside. It does violate many different statutes and constitutional rights. However, the Center for Disease Control through the Department of Justice has already appealed that decision to the Federal Court of Appeals, and the decision from that district court in Washington, D.C. was stayed, meaning that it's not final, it's not enforceable in any court. Again, this is just same thing. We just kind of reiterated on the outcome, was that judge said, hey, I'm going to give y'all proper times to resubmit everything to me, and we're going to consider it at some point in the future. And that some point in the future, like I said, could be next year. It could be the year after that, when the CDC order doesn't really even matter anymore. This is a big thing too, the notice to vacates that, property managers or, whomever you're using to send these out to tenants. The CARES Act is still in place. It has not expired. There is no expiration date on this. And this is what covered, if the mortgage on the property was federally backed or not. And being so in saying that, there are several links where you can go verify whether the owner, has a federally backed mortgage, but that law is still in effect. Many people thought, no, it got lifted because I don't have to, circle it anymore on the petition that I file with the court. Well, again, that order expired where the courts don't have to tell you to do that. They don't have to request that of you, but it is still in place. There have been several tenant attorneys that have gained access to the federal portals to verify these mortgages that to date, we're still not, I'm not sure how they're gaining access to run these checks, but they're showing up to court and saying, well, we were able to determine that not only does a mortgage exist, there's a federally backed mortgage on the property. And I know you've been waiting for 3 months now and you thought this order expired, but you gave a 3-day notice and not a 30-day. So case should be dismissed. And they're winning on that argument because, again, the CARES Act is still in place. You do still have to comply with that. That's another section, though, that only applies to non-payment of rent cases. And it's only if the owner has a federally backed mortgage on the property. And don't get confused either with, we've had plenty of people call and say, the owner has a conventional mortgage, it's not federally backed. I would say 70% of those people calling in or that say they have conventional mortgages, when we run the check, it is still federally backed. So people are getting confused that, well, I don't have an FHA or VA loan, it's not federally backed. It still may be. So I would still verify that, because again, that requirement is still in place. The petition requirements that I've kind of been talking about with the courts, they've, taken away most of them. Some courts are still requiring you to do something which they can't do. The only thing to date they can require additionally is that you have reviewed the Texas Eviction Diversion Program. Most, if you're if you're filing at the JP courts directly, they do have that checkbox on the form where you can fill it out. And if not, most of them are just asking you at the hearing, you and the tenant, hey, have you reviewed it? Are you interested in it? And then that's the only requirement that's currently still in place on eviction suits. So the Texas Eviction Diversion Program, landlord and tenant both have to agree. It does remain in effect till the end of July. And if both parties are interested in court, the judge will then abate or reset the case for 60 days. And then it can be reset at 60-day increments after that. I've had a lot of questions though of what if the tenant applies and doesn't get in, or what if the tenant applies and gets in, but landlord doesn't want to participate? Well, both parties have to participate. If they don't, you can still move forward with the eviction. This is what I just talked about, but courts requiring additional information. And this is just kind of a side tidbit I threw in here too, just in general evictions prior to COVID. You have plenty of courts that say, I can't accept your filing. You didn't send the notice. You didn't send the lease. You didn't send the military, some form that they're wanting. At the end of the day, all they can require you to do is send the petition. Any one of the courts in Harris County, if you send them Rule 510.4 little a, they will know what you're talking about and they will back up off of you. But most of them will try to ask for all of these documents, even though they can't do it. Technically, at the end of the day, if you've pled everything in your petition in regards to the eviction suit, the notice and lease aren't even required. If the tenant doesn't show up, the judge is to take that as true and move forward with the judgment in your favor. However, judges again will take it upon their own discretion to decide what is and can and can't be required. So again, if you know this rule though, they can't do it. So when they're telling you didn't file your notice, we're rejecting your filing, they can't do that. But again, it's a matter of whether you want to go back and forth with the clerks in the JP court or just do what they say. Let me back up. This is going to be the last slide. We kind of talk about the COVID orders in regards to eviction matters. So the courts, again, some are setting them. Most Harris County's courts are setting them, but most are months out right now on various different matters. And it depends on the court you file in. So kind of the gist of this would be ensure whether the CDC order does apply to your case, whether you received a declaration, and then whether you want to incur the liability with your owner or client in terms of moving forward on the eviction. The next part of the presentation is going to be really DTPA heavily oriented. So if there's any question you can think of with this, put it in the chat, or I don't know if Paula has a way for the people there to ask aloud.
I don't see anything in the chat. The group is in another room, so they would have to put themselves in the chat over there.
Got it. Okay. The next thing, this has been, it seems, the biggest scare for property managers and even law firms across the board right now on the DTPA changes. It's what kind of stirred all this up is the Consumer Financial Protection Bureau. They issued this final ruling in regards to debt collectors and how they're associated with the CDC and the eviction moratorium and what they have to actually comply with. This second bullet point on here is just kind of how the Federal Debt Collection Protection Practices Act fares into this and what exactly it means. You have you have a state one as well. You have the Texas Act also and federal. What we're going to talk about today is federal because that's the one affecting property managers and the way they handle notices and various things they're sending out right now. The way that the CFPB, again, that's the Consumer Financial Protection Bureau, they're of the opinion that tenants were not being afforded all the protections they should be under the CDC order. they felt that attorneys, property managers, owners of rental properties were lying to the tenant. The tenant saying, I think I applied for the CDC declaration, or I filled it out correctly, and the owner telling them, no, you didn't, or you don't fall under that, you're not covered, or the management company telling them that. So that's what kind of stirred about this change for the CFPB to come out and say, we're going to make a change with that, and penalize attorneys, property managers, eviction, different agents working on behalf of the owner in regards to this. And the biggest concern is that last bullet point here, where it's Regulation F that they changed, and it now requires debt collectors, which we're going to discuss, and how they've defined that as being you property managers, requires you to provide a written notice to the consumer and / tenant of the protections they may have under the CDC order. And then, like I said, this is what's caused all the fuss, is that, well, what do I have to put in that notice? What do I need to do so that I'm not subject to the DTPA violations? Because again, I'm sure, if you haven't been involved in a suit, good for you, because most of them, the DTPA lawsuits tend to be huge amounts of money, because you can get treble damages, in addition to fines, attorney fees. Tenant attorneys are loving this right now, because they can suck the management company, the owners, into these, and try to go after them for big fees. I can tell you just from a colleague, it's happened twice now already. I'm not going to name names, but there's a specific tenant attorney that's pretty fierce in Harris County, and she has decided that she's going to go after property managers filing evictions, not complying with this. And what she's doing is the property manager's filing this eviction suit in the justice court, and she's waiting to see your notice. And when she sees you didn't comply with this, she's filing a district court action against you, the property manager, and your owner client, and claiming you violated this. And she's suing for upwards of $100,000 to $300,000. Will she be successful? Probably not, but they've just roped you and the owner into a district court action that you're likely going to have to hire an attorney for you and the owner, because the owner now is going to come to you and say, well, you should have known that. But just keep that in mind, that there is an attorney right now that's actively filing those cases. So this is kind of when it took effect. It was March 29th, 2021. This is when they came out and said, hey, the American people, or American tenants, I should say, they're not being afforded the protections they should be under the law. And because of that, we're going to try to create all these unconstitutional statutes and codes that we're going to make attorneys and property managers comply with, to try to actually, get them in trouble or be fined for not helping, as they say, the American people. So how they've kind of defined this is they say that, when a tenant's late or hasn't paid some type of balance, whether it be a late fee or pet deposit fee or something like that, they're categorizing them in the group of consumer, how it's defined under the DTPA. And by that, the landlord or owner, agent or attorney, or whoever's acting on behalf of the property manager, is the one trying to collect this unpaid debt. And again, this is the Debt Protection Act. So here, because of that, they're trying to factor in and pull property managers and agents in, saying that you're debt collectors now because you're collecting an undue balance, or a due balance, by the tenant or consumer that they're trying to define. Here, this is just kind of definitions. I had emailed this whole PowerPoint to Teresa, and I'll do the same to Paula, just so that you have it and you can kind of refer to it if you'd like to. But again, they're trying to say that a tenant's unpaid rent would fall within the FDCPA's definition of debt, because it's an obligation of a consumer to pay for something arising out of some type of transaction, whether it's personal, family, or household. That's the key kind of paragraph there as to why they think the DTPA at the federal level should apply on these types of cases. Here again, so this is kind of how they define debt collector. It's the section there under the act, how it's defined. And here they've pulled attorneys. They're stating attorneys who engage in eviction proceedings on behalf of the landlord or owner to collect the unpaid rent may be a debt collector. It's may is how they've written it out now, but different cases and language they keep putting out, strongly suggests that it applies to all attorneys and applies to all property managers. And because of that, you've now been grouped into the FDCPA, which has a laundry list of different rules you have to comply with to ensure you're not in violation of any of the ordinances set forth by the DTPA when you are defined as a debt collector. So this is just kind of the further requirement, like I said, more for your reference that I'll send out later. It only applies to non-payment of rent cases, though, where non-payment is one of the reasons for the eviction. But they're trying to argue you have to give the tenant notice on your notice to vacate of what the protections they may be afforded to under the act, under the FDCPA and under the CDC order.
Kyle, you have a question.
Okay. So the question, let's see, when does the CDC notice have to be given to a tenant, with eviction or late notice? So I would say I would put it on both, because we're going to get to it in just a second, but the FDCPA has not given clear instruction on that. They've just said tenant has to be provided notice, but it definitely has to be in the notice to vacate. So to avoid liability, I would be putting that in every notice. If I'm sending something to collect a past due balance, I would be putting that language in it somewhere. Is there a required format it must be given to the tenant, or is there a specific verbiage that must be used? They haven't really come out and said that. I can tell you, like, our firm, our notices are generally 2 pages. Our notice to vacates have been ramped up to 5 pages now. So there's all different types of clauses we could talk about you can put in there, but because the FDCPA hasn't been specific with it should be this or it should be that, no one's really clear as to what exactly needs to be given to the tenants to avoid the liability. So more is better here. I would be advising them of every application they may be permitted to use under the CDC order, telling them you may be a covered person or you may not. The CDC order is still in effect. And furthermore, as the property manager, I am a debt collector. And then most of you, I'm sure, have heard the spill from one maybe calling you by accident or calling you intentionally, hopefully not. But the general, this is an attempt to collect a debt. Any information obtained by you will be used for that purpose, is generally the language that all debt collectors have to comply with, whether the credit card companies and now property managers and eviction attorneys and agents. So here so it's the Consumer Financial Protection Bureau, and what they've concluded kind of with is that they have legal aid, which is a free attorney agency for tenants throughout the state of Texas, and really for anyone who can't afford an attorney. They do all types of cases, but they keep insisting that tenants are being tricked into being evicted, and that property managers and attorneys are lying and telling tenants that the order doesn't apply to them. And because of that, the Bureau has come out and made this conclusion and amended that Regulation F section, saying, hey, you now need to show that you gave notice to the tenant of their rights under the CDC order. So again, here kind of in short, don't tell your tenant whether or not they qualify. Leave it up to them to determine that. You just want to say, hey, you may be a covered person. We're unable to determine that at this time, but you may be. And because of that, like I said, just have the clause in there, and then at least in some part of your notice indicate that it is an attempt to collect a debt. There are all kinds of clauses through the DTPA that if property managers end up getting grouped into this thing, which is an ongoing battle as well right now that I'll hit on at the end. But there are, really, I could do a whole 2-hour talk on that as to all the different clauses you will then have to put in notices, no matter what you send to the property manager, if they're able to group you into being a debt collector under federal law. So again, another lawsuit. So here, some of you may know about this, but the National Association of Residential Property Managers, along with 6 other parties, all through the National Alliance Association, have filed a lawsuit against the Consumer Financial Protection Bureau, stating that because the CDC order was challenged and held unconstitutional by those 5 courts, regardless of the appeal, the order should not, in a sense, be enforced on other individuals, such as property managers. And they're arguing that by enforcing this now on property managers and attorneys and agents, it's violating their First Amendment right, whether it be written or verbal speech, to have to comply with some type of act like this. As of now, there's been no temporary restraining order or pause, or, as of the last I checked, this thing is set for the end of July. So again, if it expires June 30th, then all of this is kind of moot. But I figured I'd at least include it on here so that you know that there is a lawsuit being filed against them. But that order is also in effect right now. So ensure that you're complying with it to avoid getting you and, of course, your owner or anyone else in trouble for that. Sorry, I was going to pull one more thing up for you here, but and Paula, for some reason, the chat keeps popping off my screen. So if somebody puts something, if you could just stop me.
Okay, I'll do it.
I saved these in two different places. I just wanted to show one more slide here that, well, not to waste time, but so again, kind of in the end, the DTPA, now we don't know whether it's going to stay in effect or not, but as of now, it affects the property manager. Put a clause in your notices that states that this, the tenant may be a covered person, and then put some type of language in there about being a debt collector. And then keep in mind from the first 15 slides or so of this that the CDC order is still in effect. It is in effect till June 30th, has not been extended as of this point. You can still file even non-payment of rent cases without getting in trouble. Just ensure that if you receive the CDC affidavit, you either advise your client that, hey, if we move forward, we could get in trouble, or ask the court to reset it. Other than that, I think I hit the big points. Is there something more, Paula? I know I had received some requests about service animals and if I could go through the TAR lease and different things, but I knew this was kind of specific to courts after COVID, so I didn't want to touch too much into other things.
So yeah, I think through HAR, through just some general conversations with people who were attending today, who may not be property managers, they were interested in covering some things I think that are starting to worry them, like assistant animals. How is the CDC orders or evictions being affected by things that are just our normal go-to problem childs? Like, what is an assistant animal? How does that affect their rental property? And is it really taking effect in this sort of arena?
Yeah, I mean, I think service animals are totally separate from the CDC order because, I mean, service animals, there are all types of federal laws you have to comply with on those. I know one question I get asked a lot on service animals is that I allowed a service animal, it was a valid service animal, and they destroyed the home. Can I still deduct from the deposit everything they destroyed? Well, of course you can. Doesn't matter whether they're a service animal or not, you can still do that. But how are they playing into these cases? I mean, most of the time service animal cases are filed in district court. They don't really go before landlord tenant judges. But I guess, is there something specific about service animals in the CDC order maybe you were asked about?
I don't know. I think it was a general question that came through HAR's process. If Rita or Teresa know, they can chime in and help us with that question. For me, and for the property management, trying to protect landlords or be a part of our regular process, how we're collecting rent. I think it's kind of interesting, though, that we're considered debt collectors when that would be almost anybody who has a note due or a payment due for whether it's a credit card or whatever. I know the difference is this is someone's home, but debt collector, I don't know, it's kind of interesting.
Yeah, it's unfortunate. It just seems kind of like every court, whether it's state or federal, is doing everything they can to work against the landlord and the property manager right now because there are so many different statutes and rules you have to comply with. And tenant attorneys are taking advantage of that because it's like, well, I can probably extend it. I can file a jury trial and allow the tenant to stay in the home. But why don't we do this? How about I file a district court action? I'm already representing you for free. And let's see if we can get $50,000 out of the property management company's E&O policy or whatever type of insurance you carry. And that's causing lots of issues for owners and management companies because they're scared to do anything right now. Because they keep getting these bogus type of lawsuits filed against them.
So are you finding that whether it's Harris County, Fort Bend, Montgomery, are you starting to see similar behavior from all the judges, or do you see differences in different counties?
So I think that Harris County is by far one of the hardest still to kind of evict in, depending on where you're at. I mean, if you're in the north side of town, your precinct 4, on Cypresswood or Spring or Humble, they're very landlord friendly, and they always have been. So they're really of the opinion, hey, just evict. That federal order, you're not going to get in trouble. Department of Justice isn't really going to come after you. But, when you hit kind of the Shepherd Court and South, they're of the opinion that, no, you're going to get in trouble. You shouldn't be doing this. Here's the affidavit we're going to make you sign so that you don't blame us. Montgomery County, I think it's open game. The 5 JPs out there, of the opinion, it seems like Texas should secede. So, I mean, whatever federal law is out there, they don't really care on federal laws. It's, hey, this is the state law. We're going to comply with that and nothing else.
So really different mindset. So I have a question in the chat. What is the best resource to keep updated on the property manager being classified as a debt collector?
It's a good question. I don't have an answer for that. I mean, I'd be on I think it's cfpb.gov, I want to say is the website. That's where they update their latest orders. And I'd probably just be Googling daily or calling, maybe I can try to provide updates to you as I see them if you want to pass them along to people. But I would do that. I mean, I don't know of something that I would think that since the lawsuit was filed by the National Residential Property Management Association, or whatever it is called, that you could get some type of update from them in terms of advising like what's happening with it.
So that's NARPM, that's our association, the Houston chapter. We do have a website, narpmhouston.com, and you can always go to the national site, narpm.org. I'll put that in the chat here in just a minute, and then you can start to see if there's anything that we can follow there through the legal channels. We do have legal updates from the national side. We've done 2 of those this year already at the chapter meetings, and they've been Zoomed. So we definitely welcome when we partner with HAR. They are great resources to help agents, even if you're not doing property management, to have resources like you, Kyle, to help clear their head and understand what they really should and shouldn't be doing as an agent as it pertains to property management. So we appreciate that. You really do give some black and white clarity on what can cause great grief from a real estate agent's perspective or a broker if they're really trying to do property management without all the tools. So that's really helpful.
Yeah, and again, like I said, I will try to, I mean, as I get updates, I'll send them to you. And then if you want to pass them along, you can, or post them on, whatever you have, you can do that as well. Just, I don't really have a good source to tell people that, hey, this is where you should go, just because I could tell you that it'd be the news, but it just like with the CDC order, people freaked out thinking the order was unconstitutional. I'm going forward when really it wasn't.
Also, just want everybody to be aware, HR will be hosting some additional risk programs related to the topic later in the year. Kyle, another good question, I think. What about timeframes? Somebody hasn't paid their rent for, let's say, 30 days. Most property managers within the first 10 days are working on sending out notices. You're late, you need to get involved, you need to get your payment in. And if anybody has a real tenant, a real problem based on COVID, are they going to bring it up then? Or are they going to maybe work the system? If you're 30, 60 days out from getting rent payment, that's a long period of time. So how long does it take to sort of see the action come to play? And then how long will it take to get from that point to somebody tenant-wise filing something at the court level to protect themselves, and then start that gamut of challenges?
Yeah, so there's a lot, I guess, to answering that. But in terms of time frame, because the CDC order is really kind of set to expire June 30th, even if it does get extended, it seems kind of like we're at the back end of this now, to where if they're even a week late right now, I'm advising property managers to send the notice because of everything going on. So the second they're late, I don't know that I'd really be cooperating. I'd just say, hey, well, I'm sending it. If they call you and, hey, I was affected by COVID in some way, well, I mean, everybody's claiming that right now, but it's, I would say like 95% of those cases aren't true. I mean, we're seeing fake doctor's letters filed with courts right now claiming they have COVID and they can't come to court for 90 days because COVID they think is going to last 90 days in their system, just all kinds of fake letters they're filing. So if I own the property or I'm the property manager, I would be sending the notice the second they're late, and then moving forward with the lawsuit. And then, even now, depending kind of on the court you file in, the hearings aren't too pushed out unless you get a CDC declaration. But even if you do, you can still kind of have hearings and updates along the way. So, I mean, quickest wise right now, even with a CDC affidavit, it could be as soon as July. I think if there's no affidavit on a non-payment case, you could still have them evicted and the entire thing done in less than 30 days. Wow.
Great, great. Well, if anybody has any questions, please go ahead and put them in the chat. We'll pay attention to that for the next few minutes. We want to thank Kyle for giving us a enormous amount of information that will help us as we continue to help our landlords. And thank you, each of you, for taking time to do this educational class to improve your knowledge on what's going on. As I mentioned, this program was recorded and it'll be available on the HAR TV YouTube channel. And before you go, be sure to be on the lookout for the next HAR and NARPM program scheduled for August 19th, and more details are coming. We also meet as a Houston NARPM chapter. Every month we either partner with HAR for webinars, education-wise. We also have a website, narpmhouston.com. You can start to plug in and understand more about what's going on the property management side. And we do meet. We have chapter meetings. And our next one, it will be this July at Do-Si-Do up on on 45 in the Woodlands area. And so we would welcome new property managers, new agents who are interested in understanding a lot more about how that all works. And we have great resources like Kyle White, who keeps us from going to jail. Thank you, Kyle. Thank you, HAR, for always helping us do the greatest that we can in our industry. Let's see. That's it. I don't see any more questions. Rita, turning it back.
I think we're good. Can you hear? I don't know if you can hear me. But yeah, we're great. Thank you so much, Kyle. We really appreciate all the information that you provided us today. It was a lot, but we know your time is valuable, and everybody else for being on the call. We appreciate you for attending and just taking some time to learn what you need to know. So hopefully we'll see you next month. And if there's any questions, feel free to just shoot us an email and we'll get back to you as soon as we can. Thanks, Paula. Thanks, Kyle. And thanks, Teresa, for all your help.
Thank you.
Bye. Thanks.
Bye.